Welcome back to the Law and Crime Network, and what a day it has been in the courtroom, in all the courtrooms that we're covering. Hello and welcome back. My name is Kenney Baden, as you know. And while I was gone, verdict after verdict, and let me just give you a little bit of a hint, not good for defense attorneys like me. Earlier today, when Stacey Delicott was in this chair, the Jonchuck jury came back. They had deliberated for about 6+ hours over 2 days, and they had options: guilty, not guilty, not guilty by reason of insanity. And what did they choose? Guilty. Guilty of the murder of his 5-year-old daughter, Phoebe, by throwing her or dropping her or letting her go off a 70-foot bridge. That's the defense opening. Bob Hille, I'd like to introduce you, my guest. And the reason why I love Bob, you know, you talk about Bob Bianca, we talk about our New Jersey kids. Another New Jersey kid, somebody who graduated Bergen Catholic High School, a Catholic person like me, you know, in this Holy Week, you know, and tried cases in front of a judge. I love Garrett Brown. We'll both talk about that later. But you have massive experience. You were the president of the New Jersey State Bar, okay? That's better than being elected like dog catcher, okay? Just a little hint, okay? Better than being elected a jury foreman, too. But when you have a case like this, here the family went missing February 4th, 2010. No one saw the dad after the dad met with this defendant, okay? They were found in November 2013. They're being tried in 2019. Generally, without regard to this case yet, who does better in a trial that is long coming, the prosecution or the defense, and why?
Well, the challenges are greater for the prosecution because of two reasons. Number one, your forensic evidence can tend to deteriorate over time, and that could impact negatively on your abilities, such as with DNA analysis, perhaps. The other thing is it's more difficult to connect the dots because as events transpire and go on, you know, parts of a crime may be located somewhere, may be moved, things may change, witnesses change, witnesses' recollections change, so that can all play into the defense.
Well, and if you took that list, that's exactly what happened here, Bob. The prosecution saying the DNA is not good, the defense saying, hey, you didn't test good DNA. It's interesting. Bob, without even knowing the specifics of the 4-month, 5-month trial, has said basically exactly what happened in this courtroom. As you know, we were covering all last week the case of Van Hemert. He was charged with the murder, the homicide of a basketball player, a college basketball player. Van Hemert relied on the self-defense theory, and let me tell you why. He's 5'7". The victim, Marquise Todd, is 6'7". So there was a good foot between him, and poor Marquise Todd obviously died since it's a murder case. Bob, one of the things we're going to talk about, but first we're going to talk about this, but we want to see the verdict because the jury was out only 2 hours. Okay, that's the jury. Bob Hille. Bob, let me just tell you, he testified. Before he testified, I thought, oh, easy self-defense. 3 college kids who are bigger, taller, stronger, come back to his house after a motor vehicle accident, and he says self-defense. Then he got on the stand. What happens when a defendant gets on the stand in this case?
Here you had discrepancies in the story. What he told the police initially, the 1 punch, versus several punches. I think that was a significant factor. The other issue, him pulling out the pocket knife and stabbing this person in the struggle, apparently the jury felt that that was not a reasonable use of force, that he wasn't in danger of death or imminent bodily harm, significant bodily.
And you can only use the self-defense killing somebody if you believe you're going to be killed or somebody else is going to be killed, right?
And they believed he was the aggressor.
And they believed it. Okay, Bob Hille, that was a defense closing argument. And I think after his client testified, the wind kind of got taken out of the sails because he said that he stabbed poor victim in the heart, in the left arm, but he's right-handed, and the victim was on top of him, and supposedly somehow he got back, and he did this. So this is where, by the way, Mr. Stretchy comes in from Michael Bryant, okay? It's not possible, is it?
It wouldn't be possible the way that was explained.
Well, that's what the defendant testified to. So
right.
How, when he testified to this, and the defense attorney says it's an absurd to charge him with murder, why is the defense attorney being absurd? And I like defense attorneys. I'm one.
I think the defense attorney is just trying to stick to the script on it and focus away from that client's testimony, focus on what they were putting in their case in general. The other problem is that the evidence here suggested pretty strongly that the defendant charged the victim.
Marquise Todd, right.
And that doesn't play well into this idea that he was frightened or that the size of the individual mattered to him.
He also ran away and threw away the knife, which has never been found. How does that help or hurt him?
Well, it suggests that he felt that the mechanism may have looked so bad that it wouldn't have helped him in this defense on the struggle.
And maybe it wasn't this little pocket knife, but anyhow, there was also drugs that were apparently the defendant didn't want found in his house. Lots of things happen in a courtroom that we don't know about because courtrooms and juries are local and we are not. Bob Hille, before we discuss what the judges did on sentencing, you're a New Jersey attorney. We deal with insanity issues in New Jersey, not because there's insane people there, but the courts have a good system set up for that, kind of like Florida here. I never got the feeling in this trial, with 27 commitments, with all the problems he had, that the defense, and I say this lovingly because I know they work their tushes off for this guy, for Jonchuck, that you never got the overall feeling of how much of his life was put in these mental breakdowns. Did you?
Well, I think the first thing is that Florida, unlike New Jersey, has a clear and convincing standard for an insanity defense. So they don't have more likely than not.
Right.
So it's a tougher burden to prove that to the jury, or make the jury have a firm conviction or belief that he is insane. And I think the evidence here, there was enough out there for the jury to consider that he was not insane when that happened. Sure, he wasn't sane to stand trial for a period of time, but ultimately then he was.
Yeah, but he ultimately was. But the judge here then sentenced him immediately. Obviously, the defense wants to make motions for a new trial,
Right.
and here it has implications because he's on medication. He's on specific medication here, and the question that we read every single day, whether prisons can really do the types of medication for mentally ill. I mean, he can't be with the general population given his mental disease. So do you think the judge should have given 2 weeks, 3 weeks? I mean, he's not going anywhere.
Well, again, that's something that, you know, the judge has full discretion on to decide, and here it's certainly ample basis for the judge to do that. Ironically, this gentleman's either going to spend the rest of his days in prison or in a mental institution.
Yeah, either one, right.
So the outcome's not really different in terms of his incarceration. The question is where, and as you pointed out, what kind of medication he'll be able to get, whether he's in prison or somewhere else.
But you know what? If the jury couldn't believe it, that he was in committed 27 times, and that had some effect because it really didn't come across to me. I mean, I don't know. Let's listen to what was presented in the courtroom that made me feel the way I did, and make probably the judge and obviously the jury. So that is defense attorney Bob Hille attempting to show that at the moment, Jonchuck, who we know has been Baker Act, that's involuntarily committed in Florida 27 times, but at the time he threw his door off the bridge, he had a psychotic break and he was sick. You mentioned to me 2 things during our watching that you found suspect.
Well, as part of his discussion or part of the case, he thought that he had to kill himself and the child because they were possessed and there was going to be harm to other people if he didn't do this act, but he didn't throw himself off the bridge. That, I think, was a significant issue based on those earlier statements. Also, he fled the scene, and he fled at a high rate of speed, which indicates that he knew that what he did was wrong. I think there's no question.
Kind of like Van Hammer at the previous case, we talked about leaving the scene of the stabbing.
Right. And I don't think there's any question that Jonchuck knew what he did. He was throwing this child off the bridge to kill her.
Let me just ask you one thing really quickly. Could the act of throwing his daughter off the bridge, could that have been so brutal to him? Because clearly he loved her, obviously, from the testimony, but that is what caused a psychotic break, not prior, that he had when he got to the jail.
Yes, but then the argument is, but he fled the scene thereafter. So if the psychotic break happened, it may have happened after he did
in the jail.
act.
That
Right.
doesn't necessarily mean he didn't have one, but the question
Right.
is when he had one. So anyhow, I'd like to read our viewers another statement that was taken by Tampa Bay Times reporter Lane DeGregory, who spoke to Jonchuck's mother. As you know, she was not in his life for most of his life because she was a drug addict. She said, quote, "Only God knows if he did it on purpose or if he's sick." And she says she wants to see him and tell him she loves him because he's my son. Well, maybe she should have been with him during his 27 commitments is all I can say. It's a true tragedy. Not obviously she had problems, but problems developed for Phoebe, and she's now dead. Break. We're going to it. Stay tuned. Okay, this is Christine Moore you just heard from. She's saying she never told Luana Simon, who is the one who may go to trial here, about the investigation. But boy, I think there's bigger issues here, Bob Hille. In New Jersey, when I practiced, boy, if I had a company or had somebody, I would go outside and hire a former U.S. attorney, not an assistant, a former U.S. attorney to come into the company and do the investigation, not general counsel who gets paid by these people, is recommended by these people. How does that affect the credibility here?
Well, it damages the credibility of it, and it also, I think, you know, shows that it's not a fair process for the victim.
But under Title IX, which gives money to make sure the women have sports and are treated fairly and aren't sexually abused, it's supposed to be fair. How do they get away with this? Forgetting, just moving Luana Simon to the side for the moment.
Well, the interesting thing in this case is going to be who Moore talked clearly to Russell. We don't know who else she talked to. We know she says she
And Russell is who?
Is her supervisor and the one who was really directly reporting to Simon on this.
So the issue is whether Russell, that when Moore talks to Russell, who is the assistant to Luana Simon, the president, is there like a wink, wink, look of the eye that Moore is expecting her to go to Luana Simon, but that there's no record that could be tracked?
Well, we know that Russell spoke to Simon. We know that the folders that they had, while Russell's identifies Nasser, Simon's doesn't, but Simon's has, under the item number 6, sexual assaults, it has a COM incident. So, you know, there's a lot of inferences that can be drawn here, maybe sufficient to have the charges go forward.
Well, and this is a very low standard, but this is a preliminary hearing. The prosecution just has to prove that there's a likelihood, really, that you know, there were a crime was committed, that Luana Simon, the president, you can't get much higher than that, right, in a college, withheld information from the police to divert attention to what? Protect the school?
Well, what's interesting here is that neither the president, Simon, or the provost supposedly received the draft of the final report or the final report.
But how does that shield them if indeed we know, or there's an implication here that indeed Christine Moore, the general counsel, would report to Luana Simon's assistant? Because why is she reporting to the assistant if she's not expecting the assistant to take it to the president? I mean, I think Thomas Show's testimony about her drawing, this is an apple, ladies and gentlemen, I know you can't see it, but drawing a vagina and saying, okay, well, I'm going to explain to you why this wasn't sexual assault. Well, I'm going to explain to you, ladies and gentlemen, why this is not an apple. It's ridiculous. Well, so I'm getting heated, as you can tell.
Well, the subject matter of Thomas Show's complaint, I think, is pretty damaging when the details of what had occurred, at least her version of it, are out there. Also, Simon had a duty to protect the university, and the question there is, did she breach that by not taking more aggressive standards here to make sure that this was a fair investigation and one that gave due justice to the victim here?
So protection of the university, and you know, I watched the NCAAs and the basketball team, and they were great, okay? But protection of the university means protection of the students. It shouldn't mean protection of the name, should it?
That's the argument that's going to be made here.
And but isn't that immorally, you know, in terms of moral judgment, isn't that the truth? Shouldn't we, these young women who were, you know, were doing nothing but you know, giving good name to the university, and there was hundreds of them who were sexually assaulted, by hundreds, and not just one or two, and that's enough, but hundreds.
Well, they may have bigger problems here, obviously, from the civil standpoint, because whether they should have done more to stop this. In 2014, you have this arise, and after that, and clearly the university knew about something. He's still there, 20 more people, women, girls, and maybe more subjected to this kind of treatment.
So, ladies and gentlemen, as we listen to this, Bob Hille has been my great guest today, but as we listen to this, there's a lot more to come. Law&Crime, we bring you everything, Jonchuck, everything, Thomas Shuck. You can only get us here. Stay tuned for Aaron's show, The Daily Debrief, next.